We're starting. Hello, everyone. Welcome to the American Diabetes Association's Fighting for Fairness webinar series. Today's session is the Diabetes Discrimination Case Law Year in Review. We want to thank the Skadden Foundation for sponsorship of our program today. A few housekeeping notes before we begin. If you want to earn CLE for this webinar, please listen to the following instructions. At 2 points during the webinar, I will share a code that you will need to put in the attendance and evaluation form at the end of the webinar. That link will be available at the end of the webinar, and we will give you a couple minutes to complete it. While the American Diabetes Association attempts to ensure that all information is accurate and current, this general information about potential legal protections and medical best practices is not a substitute for individualized legal or other expert advice and assistance. The American Diabetes Association, its staff and volunteers do not provide legal or medical advice or represent you. For detailed legal advice or representation, contact and consult an independent attorney, and for healthcare consultation and advice, consult with your professional healthcare provider. One final note, we will leave time at the end for Q&A, so please put your questions in the chat. And so I'll now pass it to our speakers, Torie Atkinson, attorney in New York City, and Alan Yatvin, partner at Weir LLP in Philadelphia.
Hi, everyone. Good morning, or it's afternoon now. What is time? I'm Torie. Nice to meet you all, and I'm really excited to talk to you about the year in review for diabetes cases. And yeah, go ahead, Alan.
I'm Alan Yatvin. I'm a longtime volunteer with the ADA, and I'm an attorney in Philadelphia.
And I should say I'm on the legal advocacy subcommittee of the ADA. And also huge thanks to Jen for putting a lot of this together for us. So 2024, big year in the world and for plaintiffs' lawyers. It's been a pretty challenging year for plaintiffs' work generally, and I think that that includes diabetes cases. One of the more kind of concerning trends is courts requiring a lot of evidence to prove diabetes as a disability. We'll get more into this later, but there have been a lot of cases sort of tossed on the first prong of whether someone has a disability at all, which is pretty surprising and disappointing in light of the ADA Amendments Act, which tried to make that a light lift in litigation. The other big one is the death of Chevron. Maybe Alan, you want to take this one?
I was going to hit it a little later, but I have to look at my slide to be able to address it intelligently. Give me 1 second.
Okay, I mean, I could just say that, Chevron deference was, it gave weight to the agency interpretations of statutes through their implementing regulations, and that is no longer the case. So for those of us who relied a lot on maybe DOE guidance, EEOC guidance, OCR decisions, sort of regulatory agency stuff, that's going to be a lot more of a fight, I think, going forward. There weren't any cases on that this year, but I would place my bets that that is something that is coming.
Yeah, I mean, it was really a Chevron deference was pretty powerful, because if there was any ambiguity in the enabling legislation, the agency's interpretation, if reasonable, was given deference, even if the court, would have decided it differently. Then in 2024, in Loper Bright Enterprises versus Raimondo, this Supreme Court wiped out 40 years of precedent. Surprising to lose precedent, huh? And said the federal courts have to use their own judgment to interpret statutes and not defer to agency interpretations. And in our context, employment and education in particular, the agency interpretations were really valuable.
Yeah. And then the last piece, just to highlight generally, is that the avenues of relief that might have been available have really narrowed. As I'm sure you're all aware, there's been a lot of governmental pauses, being people put on leave. It's unclear sort of what is happening at different agencies. One of the main venues for a lot of education cases is the Department of Education Office of Civil Rights. I'm not sure if that's going to be a good venue going forward. It's hard to say what it'll look like, but I feel pretty confident that it's just going to be a less viable path in the future. And I would say that if you do employment work, you're probably going to find similar outcomes at the EEOC. There's currently 3 vacancies due to a bunch of firings. Those people have sued, so there's litigation happening. It's kind of a mess, and so if you weren't already, you're probably going to be in a position where you might need to request right to sue letters, because the EEOC process, at the very least, is going to be significantly slowed. So I'm going to talk about employment cases. This is by far the bulk of recent case law related to diabetes. Not really surprising. But there are some interesting updates. I also do want to preface this by saying that these are only cases involving people with diabetes. There's, of course, a lot of new case law involving disability generally, which is certainly going to be analogous, certainly going to be helpful to you if you are working in that space. So please don't forget those. But we only have an hour, so I'm only going to do diabetes cases today. And not going to go through all of the details, but just a quick refresher on the legal standard for employment cases. The employee has to be disabled as defined by the ADA and the Rehabilitation Act. That means that they have to have a physical or mental impairment that substantially limits one or more major life activities, and have a record of such an impairment or be regarded as having such an impairment. That's the first prong. This is interestingly where a lot of cases fail. The second prong is that the employee has to be qualified to perform the essential functions of the job. Whether the employee is qualified and what the essential functions are is frequently litigated. And they have to be able to do that with or without a reasonable accommodation. And then the third piece is the employer took adverse action against the employee because of their disability. Adverse action was not heavily litigated this year, but because of disability it's a but for standard, which is kind of challenging to meet. So that is a big barrier. Alan, do you have your hand up?
No.
Oh, okay. I was like, you can jump in. So going to the first prong, this is does the plaintiff have a disability? As you can see, the plaintiffs prevailed in only one of the 5 cases of this past year. In the cases where the plaintiff didn't prevail, honestly, it seemed to me that the court was pretty skeptical about the merits of the case and just chose to dismiss on the first prong to save themselves the effort of doing real analysis in the but for prong of the standard. I'd be curious to hear, other people who practice employment law if they also see that a lot. I find this particularly disappointing because of the ADA Amendments Act, which was explicitly intended to make this prong a fairly light lift, and not require a lot of work to demonstrate that somebody has a disability. Nevertheless, so the one case that is great news, which is Ruiz. This was a woman with diabetes she also had a child with severe asthma. When COVID hit, her daycare kicked her daughter out for being too high risk, which probably sounds familiar to some of you. And the employee's doctor also told her that she really needed to work from home and not expose herself unnecessarily to COVID because of the higher risk of severe COVID for people with diabetes. The employer just blanket denied the accommodations request. They didn't engage in any process. The employee then tried to ask for FMLA leave, also denied. She then asked to use accrued vacation and unpaid leave. She thought the employer granted this, but as soon as she exhausted her paid leave, she was fired. They didn't even tell her. She found out because her retirement fund sent her a letter. Very classy. So the employer tried to argue here that she didn't have a disability, and she had argued in the alternative that she had a sort of associational standing on behalf of her daughter who had a disability. So she could either be discriminated against because of her own disability or because of her daughter's disability. And the employer tried to argue that diabetes was not a per se disability, and that would be enough to get rid of the case. Um, and that she couldn't seek associational standing because it wasn't available in the Fifth Circuit, and that they didn't have notice that she had disabilities. The court was not having this. They denied the motion on all counts. What's really helpful here is that the court made clear that a disability doesn't have to be a per se disability, though frankly, I would probably argue that diabetes is, but that it has to be an individualized analysis. And in this case, she clearly had a disability and a doctor's note telling her that she had a disability. Um, and also really good, the court recognized that while the Fifth Circuit hadn't ever opined on this kind of associational discrimination claim, it said that a claim could exist. So she won on that too, which is pretty surprising. And it's good news in the Fifth Circuit, which is not a sentence that most people get to say very often. Um, so for the bad, the Susie case is it's a postal worker who had a pretty horrific workplace accident. His foot was run over by a dolly. It resulted in the amputation of several toes. This was a really weird set of facts, though, because the plaintiff pled that the diabetes substantially limited only his ability to interact with others, and no other limitation of function. There was no record evidence of a limitation in interacting with others. There was no prior accommodation request. And the employee actually took the position that his diabetes didn't interfere with his ability to do his job. So I'm not really sure what led to that particular pleading. There was also some like workplace drama previously that seems to have informed this. But basically the supervisor in question, the allegations that the supervisor didn't allow the employee to go home and seek treatment. This was disputed, but the judge just said he didn't have a disability, which I think is kind of wild in this circumstance. But my guess is that the judge just didn't want to delve into the merits, and there was no specific pleading about what the limitations were, because the plaintiff also chose this sort of strange allegation that the only limitation was interacting with others, for which there was no evidence. Um, the next three are all people who were terminated for some kind of misconduct. Um, Hewley was a flight attendant who was terminated because she provided her credentials to another employee to basically call out sick for work on the scheduling system. She had a record of an accommodation not related to this. But what happened was she was out of the office, not at work, for some kind of legal proceeding in which she was arrested. She was taken to the hospital to be treated for her diabetes before she went to jail. But the issue was that from jail, she was unable to call out sick or otherwise call out from work. And her supervisor was like, well, you can ask like a friend or a coworker to do it for you, which she interpreted to mean that she gave her username and password to a coworker to log into the system, and that was a terminable offense. The court found that she didn't have a disability, that she didn't show any impairment that restricts her major life activities. And in this case, it seems pretty clear that that really had nothing to do with her terminable offense. Hamilton also has not great facts. It was someone who admitted that they were performing really poorly. They were put on a PIP. They were transferred to another position. The thing that I really don't like about this decision, and I'm sorry for those of you who practice in Kentucky and have to deal with it, is that the judge said it is difficult to establish a claim for disability discrimination based on a diabetes diagnosis. Really? And said, although an individual's diabetes can be so severe that it substantially limits their major life activities, numerous federal courts have held that diabetes, even when accompanied by the use of medication and dietary restrictions, is not necessarily a disability. I find that wild. I also don't think it has anything to do with the facts of the case, so I don't know why the court insisted on putting it in there, but you should be aware that that is there. If you are practicing in this area, it's really unfortunate language that I think is completely wrong. Singh is another misconduct case. It was an IRS employee who was terminated for having unsecured taxpayer information in his daughter's car. Don't do that. While he had a lot of medical conditions, including diabetes, the main claim is that the employer should have provided an Uber to transport documents for him, so he wouldn't have to lift boxes. But there wasn't a prior accommodation request, and the manager seems to have tried to like help him with certain things. So the facts on that were not great. Um, Generally on this, my sort of takeaway are that you have to do a lot of work to really spell out how diabetes is a disability and how it impairs the body's function. This seems very obvious when the ADA Amendments Act says that impairment of the endocrine system is a disability, but here we are. So if you are pleading a case, like really plead all of the different ways in which it can interfere with your work and it impairs the employee's health and life. Um, all right. So the next prong, um, they have a disability, but are they qualified for the position? There were only 2 cases on this year. The Gomez case is a summary judgment appeal. This one's pretty interesting. The plaintiff was a street cleaning supervisor in Hawaii. He was out on leave, which isn't actually related to the case. And when he was out on leave, they revised his position description. Suspicious. And the new position description required operating a type of really heavy vehicle that at the time required what was called a medical examiner's license to operate. And for those of you who don't remember this unfortunate era, this was a type of blanket ban where if you have certain conditions, including diabetes, you just can't do certain jobs. I mean, they were not individualized assessments at all. This is not the case anymore. This is not the case, but at the time it was. And the court actually found for the plaintiff because there was this question about whether needing to operate this much heavier truck was actually an essential function of the job. The plaintiff had submitted evidence that 99% of the time he drove a much smaller truck that didn't implicate this license at all. And it was fine. And it was only when his truck was out for repairs that he had to use a different, bigger truck that implicated this license. So there was a question about whether this could even be a core part of the job. And the court also found that there was a dispute about whether, as a reasonable accommodation, he couldn't have just been allowed to use the smaller trucks. Great question. So that one is really interesting. The Gross case is a lot less successful. This was a plaintiff who, due to diabetes, had several toe amputations, and they weren't able to stand or sit, or sorry, they weren't able to stand or lift anymore. And so there was actually no dispute that she had a disability or that the job she was previously in, which was a warehouse worker, did require a lot of standing and lifting, and that she wasn't qualified to do that anymore. The issue was that she had sought to be placed in a different position that she believed would allow her to sit. The employer said, sure, go ahead and apply for those, but they never interviewed her, and they certainly never offered her any of those jobs. And it appears that's because the employer believed she wasn't actually qualified to do them, because the jobs did in fact require a lot of standing and lifting. So the employer terminated her when she exhausted her short-term disability leave, and the court found, look, she wasn't qualified to perform the job that she previously held, and she also wasn't qualified for any of the jobs that she was trying to change to, so there wasn't a discriminatory intent here. The upshot, I think, of this is that it's really important to show that there is some accommodation out there that would enable you to perform the essential functions of the job. Um, you know, sort of try to do your homework on that and make sure you plead that really, really well. That an alternative position would be able to meet the employee would be able to meet the essential functions. Reasonable accommodations. this is a few more mostly good news, actually. The Huddleston case, there's a bunch of COVID cases that are finally like filtering their way through the courts. And the Huddleston one is one of them. This was a bus driver in Atlanta for MARTA, who, as a bus driver, had a lot of close contact with the public, of course, which abruptly became extremely dangerous when the COVID pandemic hit, and she was at high risk for severe complications. So her doctor requested that she be released to not work in a public facing position. And the employer said, okay, well, if you find another job position you're qualified for, apply for it. And so she did. She applied for like 7 positions. Marta admitted that it failed to consider her for any of the positions and also admitted that she was qualified to do them. And so the court in this case found she definitely had a disability and the employer failed to provide reasonable accommodations. It's not really clear what happened and why Marta just didn't engage in the process at all, but they sort of conceded those points. Another interesting note about this case is that the employer also made this argument that because they gave everyone masks and recommended masking on the bus, that would be a sufficient accommodation. And the judge rejected that and said that's a general precaution for public welfare. That's not sufficient to satisfy a request for an individual reasonable accommodation. So that's good to know and interesting. Mendoza and the EEOC, these are both what I would consider run-of-the-mill accommodations cases, where the employer failed to do something really, really basic. The Mendoza case, this was a private settlement, so it never got to an order. But and the EEOC was also a settlement where I think they filed the case and the settlement at the same time. But in Mendoza, this was a plaintiff with diabetes who requested breaks to go to the bathroom and also to eat snacks, and to monitor his blood glucose. These were just denied. He wasn't allowed to go to the bathroom, and he ultimately urinated on himself in the middle of like the factory floor. He wasn't able to treat his lows, which was incredibly dangerous. And then he was forced to take unpaid leave because they wouldn't give him any of these accommodations. He tried to come back from the leave and requested additional accommodations regarding lifting and other sort of bending things. These requests were entirely ignored. He went back on leave. They then denied all of his requested accommodations with no explanation. And that case settled, as it should. The EEOC case is really, really similar. The employee just asked for occasional short breaks to monitor blood glucose and to eat and drink. The accommodation was initially granted, and then they fired the person. And UPS wound up paying $150,000 to settle that, and as a consent decree, and they have a hotline now. So yeah, bad actors there. Um, the one unsuccessful one is another COVID case, Hicks. This involved a nurse with diabetes who sought an accommodation when the pandemic hit to not see COVID positive patients or screen them, because of her own high risk. The employer actually granted this exemption for a long time, but as the pandemic sort of raged on, the employer was like, look, we are overwhelmed. Intake is a part of your job. You have to do these screenings, and that does include nasal swabs for some people. You really need to do this work. We can't give you the exemption anymore. There's sort of a dispute about whether she was offered some other position, but the employee just filed for retirement, and sued. The court didn't disagree that she had a disability, but the court found that COVID screening was an essential function of the job, and so the accommodation can't be to not do that. The court was also clearly not pleased that the plaintiff didn't seem interested in engaging in the interactive process at all, and that she just immediately filed for retirement. So again, the takeaway here, I think, is both sides really do have to engage in the interactive process. Terminations. So, Andrade and Wallenstein are sort of exceptional cases, I would say, because they have really explicit animus. Hello? Can you hear me now? All right, I don't know why my headphones just went off. But I was saying, the first two are really exceptional in that they have explicit animus about disability, which you almost never see. In Andrade, the employee informed the employer about his diabetes, um, and he did his job fine for 3 years, no problems. Suddenly, the business started to expand, and the employer started making noises that they had concerns about plaintiff's health, suggesting that he find another job that was better suited to him. They fired him, and they told him when they fired him that it was due to the stress of his position and the concerns that they had for his health. As a lawyer, there's really nothing better you can hear than that. So, um, the court found he established a strong causal connection between his termination and his disability. Wallenstein is pretty similar, but in a almost more sinister way. The This was a medical assistant at an urgent care center who had several disabilities and had various limitations. Her employer was fully aware of them. The office protocol was to have two medical assistants for each shift so that they could, like, you know, switch off. But she was only ever staffed alone on these long, long shifts with no one to help her. She repeatedly requested just to be staffed with a second person, which was required at the company anyway. They denied it. The supervisors liked to condescend to her constantly, telling her that she just wasn't cut out for the work. And they kept comparing her to her younger and non-disabled colleagues. They fired her and they replaced her with a younger, non-disabled medical assistant with no previous experience. So the court found that the plaintiff's disability was clearly the real reason why she was fired, and that she was generally treated far less favorably than her non-disabled colleagues. Um, those two are unusual for having such explicit animus. The remaining cases don't really have the animus, and therefore I think it's a lot harder to sort of push the court over the threshold. So DeVito, this was a lab manager. He worked super, super long hours because he worked in a lab, and he was having a lot of performance problems as a result. He said that the excessive hours made it really difficult to eat lunch and dinner, which, as a person with diabetes, was really important to managing his own health. So it seems like it was a little bit of a cycle. And he requested an accommodation to limit his workday to only 10 hours. Oof. And no weekends. He was fired a few weeks later. The employer says that they actually decided to fire him before he submitted the accommodation request. And I should say this is sort of a split decision. He won some and he lost some. So the judge said that there was no dispute that he had a disability, but they couldn't find that the termination was motivated by disability. There was really a long history of performance issues, including like his subordinates quitting and telling him and the employer to their face that it was because he was a terrible boss. Not great. Um, on the other hand, he actually did win on a failure to accommodate claim, um, about the adjusted work schedule because they never actually engaged in a interactive process, about his request for the schedule. And obviously, the employer says, "Well, it's because we already decided to fire him." But the judge seemed to find that unpersuasive that they still did have to engage in the process. And I think the court found it particularly suspicious that his replacement was given a strict 40-hour limited work week, which implied such a schedule would in fact be reasonable and not impose a hardship. Um, so that one that was split. Hicks, Rios, and Shears were all unsuccessful. Hicks was terminated for misuse of FMLA leave. And this is complicated set of experiences, but she had type 2 diabetes, had an existing accommodation for when she had flare-ups, and wanted to be excused from mandatory overtime, and they granted all of those. But she started having panic attacks at work due to other disabilities, and um, she wound up going on vacation for mental health reasons. She believed that she could use FMLA leave. for that because it was for mental health reasons. The court did not think that was for mental health reasons. And the court, this one is interesting because there were some animus-y comments from her supervisor who told her that she needed to lose weight and, shamed her basically for having type 2 diabetes and told her she could cure herself and awful, awful, awful comments. And the courts found that while the comments were uncomfortable and demeaning and likely inappropriate, okay. They weren't severe or pervasive enough to constitute harassment, and they had happened 8 months before she was fired, so there was no real close causal connection. Rios was a security guard who fell asleep on the job. He said he wasn't asleep, but he was unconscious due to hypoglycemia. As you can imagine, even if true, that is not a great fact. And he never told his employer about diabetes or requested an accommodation. So the court said, no, there's no failure to accommodate. This was not based on his disability. Shears is another kind of strange one. This was a worker at a nuclear facility who was fired for inaccuracies on his time records that inflated his time. He did have a prior accommodation request, and there was some sort of outage that required 24/7 shifts, which included a night shift. And he asked his supervisor not to do the night shift, but it's not clear whether he explained why. It turns out it's because the diabetes affected his eyesight and his night vision. Um, but the supervisor didn't realize that was a disability related request, and so the supervisor basically was like, we all got to work. But when the employee eventually provided a doctor's note, like two or 3 weeks later, they immediately granted the request. So it was after this that he was fired for what appeared to be inflated time records. The employee then tried to say that the time records were a sloppiness that were caused by confusion from his poorly controlled glucose levels at the time, but the employer had no idea about this. This wasn't raised at any point prior. He never requested an accommodation for it. So the court found that the disability wasn't the cause of the termination. Um, my sort of takeaway on this is that terminations are generally pretty challenging because outright animus isn't typically really obvious, and usually the only reason you're in court is because something bad happened that somebody got fired for. So showing the pretext is really an uphill battle. But if there's a clear record of accommodations requests, particularly doctor's notes, that can really help you. Home stretch, unemployment. Um, two, two random cases. One is Johnson. It's a hiring case. There aren't a lot of these for a good reason because you usually don't know why you aren't hired. But in this case, she did. She was an Air Force veteran. She had a service-connected disability. She applied for another civilian Department of the Army position, and she got a disposition letter that said, during an audit of your application, the selecting office found that you're not eligible for this position based on medical reasons. Therefore, you were removed from the certificate or list of highly qualified candidates. The employer said this was an error in a drop-down menu. The court said it's direct evidence of discrimination. Kelly is a direct threat case. I actually expected to see more of these. Direct threats are issues where the employer is alleging that the employee presents some sort of danger to themselves or to others. With diabetes, it typically comes up with hypoglycemia or some kind of unconsciousness or kind of that sort of situation, and that is what happened here. Plaintiff was an electrician with the CTA in Chicago. They had a really bad hypoglycemic episode at work after their CGM failed. She was unconscious. She went to the hospital. And the next day, the physicians, including a third-party evaluator brought in by the employer, all cleared her to return to work. But the employer was really, really concerned about her returning to work and wrote a lot of emails asking, how could this person be returned to work? And while she was on leave, a third-party evaluator who had originally cleared her to return to work said, no, 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 you're not fit to return to work. just did a 180. They went back and forth on this for 15 months until the CTA found her fit to work and reinstated her. So the issue that was left really was whether the employer's concern over that period that she was a direct threat was legitimate, and whether the failure to reinstate her was discriminatory. There's genuine issue of material fact on that, so you will have to tune in next season. And those are all the employment cases. I would say the themes here are really the importance of properly pleading diabetes as a disability. How does it impact your major life activities? How does it impact your job? Spell it out, right? My endocrine system doesn't work. It causes confusion. I need breaks. All those things. When those things are not well pleaded, the judges often use that as an excuse to toss a case they're skeptical of on the merits. Doctor's notes matter. Letters matter. For reasonable accommodations, you have to actually ask for them, particularly before the performance problems begin. It's there's a lot of, as you see, cases where after the fact someone tries to attribute the terminable behavior to some sort of disability related thing, but you really have to start that process before, and document it and put it in your complaint if it did happen, please. And the accommodation has to be reasonable. You can't avoid essential functions of the job. And the interactive process, it has to take place. It's not enough to just assume that a proffered accommodation won't work, like the nurse who just resigned. And on the employer front, they can't just refuse to engage in it. So yeah, that's employment.
So
Before you get started, I just wanted to share the first course code, and that code is 7352.
So policing and correction cases, this slide is perhaps a misnomer because there aren't really any 2024 diabetes policing cases, which is a good thing. I mean, the word is out, and police department, nothing's perfect in policing, but police departments across the nation are becoming more sensitive to um, diabetes, epilepsy, autism encounters, and they're training better, and they're to recognize and how to respond. So certainly not perfect, but there is progress being made in that area. Of course, in the correctional setting, things are perhaps a bit different. The Eighth Amendment is the amendment against cruelty, cruel and unusual punishment, and that arises for sentenced prisoners. Similar sorts of claims in the correction center for pretrial detainees, for example, people who are in county jails awaiting trial, would bring similar claims that they would bring under the Eighth Amendment, they would bring under the 14th Amendment. But depending on your circuit, the law may be slightly better on the 14th Amendment claims than they are under the Eighth Amendment claims. But they're difficult cases. There are a lot of hurdles. The Prison Litigation Reform Act, the requirements of exhaustion, the issues with inmates proceeding in forma pauperis, where you have an inmate who's made multiple attempts. There's a 3 strikes problem in the Prison Litigation Reform Act, where unless you can show risk of actual physical harm, 3 strikes and you're out. And under the Federal Tort Claims Act, which is another way to bring some of these prison health cases, you have to bring your complaint within 6 months. You have to allow a period of time for the agency to review your claim before you can even file it, which makes it a little different from the prison litigation reform exhaustion requirement. But for example, there's case law that says if you don't wait for a resolution under the Federal Tort Claims Act, you're out of court. So there's certainly procedural hurdles that have to be addressed. But let's look at some of the specific cases. So Cross v. Bushman is discussed in your materials, and it's an interesting. Get to my notes. Sorry. I should know this case since Jen wrote a brilliant amicus brief in the Third Circuit, which I proofread and signed, so I should be able to remember it. But basically, Mr. Bushman was a federal prisoner with diabetes. He sued under the Eighth Amendment for damages as a Bivens action. He, if I recall correctly, he did originally bring a Tort Claims Act, a Federal Tort Claims Act claim, which he abandoned at some point. IFP pleadings are always a problem, especially if you're the attorney who ends up taking over the case at some point, either in the lower court or on appeal. But anyway, he complained that he was repeatedly not receiving necessary medical care for his diabetes. And the district court ruled against him on a summary judgment, saying he had failed to allege that he suffered harm from the lack of medical care. So in the Third Circuit, our brief focused on, diabetes and the risks and the prison setting and, the actual harms. None of that became an issue in the Third Circuit. The Third Circuit focused on the new law relating to what's called the Bivens action. Bivens is the case that allows plaintiffs to allege constitutional torts against the federal government. Section 1983 is the vehicle for alleging those same torts against local municipalities and individuals. But in the federal context, if you're not bringing it under Tort Claims Act, you can bring it in the Bivens the Bivens area. However, the Supreme Court in Egbert versus Boole, that's EGBERT versus Boole, BOULE, in 2022, looked back to the old Bivens cases, particularly a case called Carlson, and said that even though Bivens permits suits against federal officials for excessive force under the Fourth Amendment, its application in the Egbert case, which was a Border Patrol officer, Customs and Border Patrol officer, getting into a dispute with I believe it was a restaurant owner who asked him to leave, and the gentleman got knocked down. So there was an excessive force and a First Amendment claim, and the Supreme Court said that expanding Bivens where there are national security concerns like this would be a judicial intrusion and inappropriate in this area, and that the First Amendment claims were a novel concept, and there's no factors weighing in favor of judicial extension of Bivens to that claim. And so basically the significance of Egbert is that if it's not a classic Bivens case, you've got to show that there are reasons why it should be extended. And in most cases, courts are going to find that Congress is better suited to authorize a damages remedy. Now, the Supreme Court didn't completely gut Bivens, but they really narrowed it by referencing back to a case called Carlson versus Green, which was a 1980 case, which talked about Bivens and the situations under which it can be brought, namely that it can be defeated by special factors that counsel hesitation on the part of a court in the absence of any affirmative action by Congress, and the circumstances suggesting that a judicially created remedy might be inappropriate. And but Carlson in 1980 left Bivens pretty much intact. Egbert versus Boole has really narrowed it away, and that's what the Third Circuit case, Cross versus Bushman, went off on and said, hey, the district court judge didn't do that analysis. So the case needs to go back to the district court to do the analysis of whether this case can be brought under Bivens or not. Unfortunately, the postscript is that Mr. Cross, always forget which is which, Cross, the plaintiff, died while in custody, probably connected with complications from his diabetes. So this case, as far as we know, has died with him. The family was considering bringing a wrongful death case, but we haven't been able to find any evidence that they ended up doing that. So Cross versus Bushman had the potential to tell us something about diabetes and Bivens' actions, but it didn't. All it tells us is that Bivens has to be addressed in the first instance by the district court, and it's case specific as to whether it can be a Bivens claim. Raymond versus New York is a case where two state inmates were disqualified from an early release program because of their medical condition. One had diabetes and the other one had a lumbar disc disease. And this program, you could get in by being placed in it if you met certain criteria by the institution itself or by court order. And if you were placed by court order and you didn't qualify under the institution's requirements, you could still go into the program if you were otherwise qualified. And they had like an alternative type of program. The programmers, the shock program, as it was called, the statutory program, was a bit like a boot camp, and there were physical requirements as part of the eligibility. And the prison the facility medical director just decided that these two medical conditions ruled them out. I mean, it made no sense at all. It wasn't like they were running, that they were, swimming in the Olympics like Gary Hall, a person with type 1 diabetes who won 13 gold medals, or Jay Cutler, who was an NFL quarterback with type 1 diabetes for 12 seasons, or Sophie Shunk, who is a marathoner and former Marquette University soccer goalie, or Katie Bone, the speed climber, who's an American Ninja Warrior champion, competing as an Olympic hopeful for 2028. So the just saying because you have diabetes you couldn't meet the physical qualifications was silly, and the court agreed. They rejected the plaintiff's claim. They granted partial summary judgment. The decision's worth reading just because it's so comprehensive. The judge did a pretty good job of covering all the bases, including the defenses thrown up by the defendants. One interesting aspect is that the program has been was completely reformed during the litigation of the case to make it so that people like these two plaintiffs would have been eligible. the one interesting aspect of it is that emotional distress damages, which became unavailable in 504 ADA cases after Cummings versus Premier Rehab versus Keller from the Supreme Court a couple years ago. In this case, they argued that they weren't seeking their emotional distress damages under the ADA or 504. They were seeking them as a contractual right that they had um, um, a contractual right to these benefits and the loss of liberty damages for the additional time they spent in prison. Scott versus Pennsylvania Department of Corrections. This is a pro se plaintiff with diabetes who filed a claim against defendants for lack of accommodations in medical care. And the court there found that there was a risk of imminent serious danger to him and allowed him to proceed in forma pauperis. So this was at the very initial stages of the litigation. I was telling you about the three strike problem on the PLRA, the Litigation Reform Act. He would have been out of court. Had to move on to education, I'm being told. The only thing I want you to remember is that decisions about a prisoner's medical treatment generally do not give rise to a claim under the ADA or the Rehabilitation Act, because they prohibit disability-based discrimination, not inadequate treatment for the disability. Moving to education cases. We covered Chevron, Loper, and OCR, so that's some details, but we can skip over that slide to the next one. And let's move to the first case, which is MF versus New York Department of Education. This is, we're getting the band back together because this is how Torie and I originally started working together. This was a case brought by the American Diabetes Association as a class representative for injunctive relief, and three families of children with diabetes in the New York City school system. And the suit was initiated at the end of 2018, was it, Torie?
Yep.
And the issues were that students with diabetes were not getting timely 504 plans, either to cover them at the beginning of the year, whether they were newly diagnosed or whether they had plans in previous years. So that was one of the issues that were addressed, that they were being excluded or segregated from their classmates, certain activities, field trips, or being required to go to the nurse's office for care tasks that could have been performed in place, and training for staff, contractors, nurses, paraprofessionals, bus drivers, etc. So the school district very quickly agreed that there was a legitimate class. So the class was certified basically on consent, and we started settling it in pieces. Memoranda of understanding were entered, and they started making changes. And ultimately, in the spring of 2023, the court approved the settlement agreement, and we've moved into the monitoring phase. Last year was supposed to be the first year of monitoring, but because of reporting issues with new systems being put in place, the 3-year monitoring period was extended, and this year is the first monitoring period, and we just got the reporting. So some things are better, some things still need work. Torie, anything else you want to add on MF?
No.
Okay. US versus Spanish Schoolhouse is a epilepsy case, and I'll let you read the case notes because that pretty much covers it in the materials you received. US Creative Interventions was a settlement with the Department of Education Office of Civil Rights, which, as Torie noted, may lose, if it exists at all, it may lose some of its resources to be able to do these sorts of things. But Parents enrolled their child with autism, who was then diagnosed with type 1 diabetes. They were prepared to provide, everything, the materials, but the school would not monitor or address if there was hypoglycemia. Parents unable to provide full-time care themselves, put the kid in a half-day preschool, and half-day the parents sat in the parking lot to be available if there was an issue. And the school was a complaint was filed with OCR, and the school originally agreed to make changes, and there was a settlement agreement. I added OCR complaint in Leona Group to the materials, even though it was 2023, because it's an interesting case about the interaction between state and federal law on 504. Before school year, the parents asked for a 504 meeting. The school said, Arizona law says we have 45 days after school starts to do classroom observations. So no, we're not giving you a plan. OCR said, there's a difference between child find and right to accommodations. And you have to plan immediately when you're on notice that a child with disability needs accommodations. Okay, Jen, I made it by 1 minute.
I see one question in the chat that I'll just answer really quickly. The question is, for the cases finding that there was no disability in the employment context, I assume, was the disposition on a motion to dismiss or a motion for summary judgment? It's actually both. Of the 5 cases, 3 were a motion to dismiss and 2 were summary judgment.
Thank you, Torie. Thank you, Alan. I'm just going to highlight a couple of our resources really quickly. First, our standards of care in diabetes. This is a great place to cite if you need to cite about the science of diabetes. We also have several advocacy statements that are often cited in a lot of this litigation that combine the law and the science of diabetes. So I would definitely take a look there. We have resources on public accommodations and other areas on our website. And you can also view the recordings of earlier sessions at diabetes.org/fightingforfairness. Several of you have signed up for our Legal Advocacy Attorney Network listserv. Thank you for doing that. If you're interested in signing up or not sure if you have yet, feel free to reach out to me directly. You've all received my contact email this morning. And so now for the last code and the course eval, the second code is 4727. And I will put the link in the chat if you're unable to use the QR code there. Thank you so much, everyone, for attending. I hope you have a great rest of your day.